Okay, we are back and ready to go. Do you need to call the case, Mr. Hibner? I can't remember if you already called it.
Family Trust Services, LLC et al. Versus Greenwise Homes, LLC et al.
Thank you.
Good afternoon, Your Honor, Your Honors. My name is Ned Hildebrand. I represent the appellant defendants in this case, Charles Walker, John Paul Johnson, and Greenwise Homes, along with my colleague, Gray Waldron. I'd like to reserve 5 minutes for rebuttal. Your Honors, we are the Rule 11 petitioners in this case, and we present one single question for this court's review, and that is, after a unanimous jury verdict, when the unsuccessful party moves the trial court for a new trial, not based on errors with the trial, evidence that shouldn't have been admitted, but simply on the 13th juror standard, that the trial court, exercising its role as the 13th juror, should pass upon the evidence and disagree with the jury's verdict. And the trial court denies that motion, but in doing so applies the incorrect standard of review as the 13th juror. Should the remedy by the Court of Appeals be a mandatory, across the board, in all cases, new trial, or, alternatively, should the remedy be remand back to the trial court to apply the correct 13th juror standard? Our position is that the latter option is preferred. Now, we acknowledge that in 1995, this court decided State v. Moats, which dealt with this exact issue. This was a criminal case. And in that case, this court held that a new trial and not remand to apply the correct standard was the appropriate remedy. And it held that way because of what it found to be the practical concerns of the trial court having the recollection of the credibility and the demeanor of the witnesses in the testimony.
So, Mr. Hildebrand, is it your position that this court would have to overrule Moats to rule in your favor?
Yes, Your Honor, I believe so. And I think it's significant that Justice Jarwada gave a very persuasive dissent in that case, right? He said the majority was ignoring the obvious alternative remedy of simply asking the trial court to apply the correct standard and giving the trial court that discretion. And the result would be simple. If the trial court applies the correct standard, it could either grant the new trial or deny it. But if the trial court couldn't remember, and based on its review of the record and its review of everything, it didn't feel comfortable deciding whether it agreed with the jury or not, then the trial court could make that determination.
Before you get too far down the road of talking about the merits of your argument, I do want to address waiver.
Yes,
there is a question here about whether this argument is properly before the court, whether it was preserved and presented below. I think you argue in your brief that you really didn't have the opportunity to raise this issue until the petition for rehearing before the Court of Appeals. But in looking back at the Court of Appeals briefing, I mean, the other side plainly asked for the remedy of a new trial. I mean, it's in the heading, it's in a heading of its brief, it's in the text of the brief that, a new trial would be warranted if the court were to grant relief based on this 13th juror issue. So why couldn't you have made this argument in your responsive brief in the Court of Appeals? I mean, the rules of appellate procedure, require an appellee to answer the brief of the appellant, and this was something that the appellant raised below.
Yes, I think you're correct. We were the successful party at trial. We were the appellees in front of the Court of Appeals. We had no issue with the trial court's decision. My client's position was the trial court correctly applied the standard and denied the motion for new trial. The Court of Appeals agreed. So when we did not initiate the appeal, we took no issue with the trial court.
But you have to respond to the arguments of the appellant, and the appellant argued that there was an error with how the trial court carried out its 13th juror role, and that because of that error, a new trial should be granted. And the rules do require you to respond, to answer the brief of the appellant. So why didn't you at that point argue that, well, even if you agree with that, you should remand rather than award a new trial?
Thank you for the question. I believe a new trial should occur is in the context of the trial court should have awarded a new trial when it couldn't apply the correct standard. But as far as that issue is concerned, the issue on appeal, we are required under Rule 27B to designate, the appellees are required to designate additional issues if they disagree with the verdict. The question.
Well, you
before
have
the
to
Court of
respond to
Appeals-
the argument. I mean, you have to say why the appellant is wrong in any respect with what it is arguing in its opening brief.
Yes.
Do you not?
Excuse me. Yes.
Okay.
I'm sorry.
So why? I mean, I'm just looking at your brief. You know, it said that the heading, the first heading in the argument section of the appellant's brief is the trial court abdicated its function as the 13th juror, requiring a new trial. And there's a sentence that follows that in the next paragraph. A new trial is required. I mean, you were on notice that the plaintiffs, or the appellant was asking the Court of Appeals to award as a remedy a new trial for this error. Isn't that right? I just am not understanding why it's your position that you didn't, the first time you could raise this issue was in the petition for rehearing.
Our position is that what we were addressing is whether or not the trial court effectively applied the 13th juror standard. We asserted that the trial court did. We did not designate that as an additional issue because there was no error of the trial court we sought to rectify. If the issue is that if you do not, an appellee waives an argument as to the remedy that the Court of Appeals could hypothetically provide in the event of a reversal of the trial court's judgment, and the failure to address that is a waiver in all cases, we think that position would be untenable. I think that
Well, it's part of the appellant's argument. I mean, the appellant makes an argument in its opening brief, and then you have an opportunity to respond to that argument in all respects if there's anything that you disagree with. And I mean, I would think that at the time you may have disagreed with their statement that a new trial is required because of this alleged error with the 13th juror.
Well, certainly. We also disagree with the threshold issue of whether the trial judge didn't exercise their discretion. But I think when you look at Rule 27B as to when an appellee has to raise additional issues and what context they would, and you look at the Payne case that was cited in the plaintiff's brief as the basis for this waiver argument, and that case was materially distinguishable in a way that I think is illustrative here. In the Payne case, the defendant, while successful at trial, the trial court did not rule on the plaintiff's motion for judgment notwithstanding the verdict. The defendant seemingly not caring because they won on a separate issue, but that was an error of the trial court in that case not to rule on that. So when it comes up on appeal, the defendant, as the appellee, was obligated to raise that as an additional issue, an error of the trial court.
Right. Well, that just, the fact that it was not an error of the trial court just means that you were not required to raise this issue in the trial court. You weren't required to, raise it at all at that level. But I don't want to take too much time from other issues, but I guess let me just follow up with this question.
Yes.
Let's assume that I think this issue was waived. The court does have discretion to consider issues that were not preserved or presented below.
Yes.
Why should we exercise that discretion here?
Well, certainly, I believe Rule of Appellate Procedure 13B speaks to that. If necessary to prevent needless litigation, to prevent prejudice to the parties, or to protect the public interest, and I think in this case each of those elements is plainly here, prevent needless litigation. This case was tried over 6 days before a jury of 12 jurors and 2 alternates. There was no issue taken with the way the trial was handled. It's purely about the standard of review that the trial judge applied for the 13th juror. And as mentioned in our brief, which I'll get to, the 2 major developments, legal development and technological development. I'll start with technological development. The unique thing in this case is that this entire trial was completely video recorded. Tennessee Supreme Court Rule 26 provides that trial courts can outfit themselves with video recording, which will serve as the official appellate record, and this case took place in a courtroom with that video record. So the entire trial exists to be viewed.
But don't we have only 2 courtrooms in the entire state that do that? We can't have one rule for the courtrooms in the country and others for courtrooms in the city, can we?
I don't think you need 2 rules, Your Honor. And what I would say to that is, with respect to, I think this question was answered, this court decided in State versus Ellis, an opinion that Justice Bivens authored and I believe Justice Kirby participated in. That was a parallel case, very similar to this, but in the context of a successor judge. And in that case, the court found that a successor judge who did not witness any portion of the trial, hear any of the witnesses, see any of the witnesses, could nonetheless serve as the 13th juror and apply that standard, and that was based on a written record. So, frankly, I think it's we're struggling to see how that decision in Ellis is not an endorsement of Justice Jawada's dissent in Moats. And with respect to your question about not all courtrooms are the same, well, of course we agree with that. Not all courtrooms are the same, and that's precisely why this should be the rule in all cases. Because if this is not the rule, then that means that we're going to ignore all of the courts which have implemented this technology, and the state has spent resources implementing that technology. We would ignore that. Would the better response not be, in all such cases, remand to the trial court to apply the correct standard? And if the trial court feels, based on its lack of resources or the amount of time, it doesn't have video, the written transcript, in Ellis, a written transcript was sufficient for the successor judge to serve as the 13th juror.
So you're saying that Justice Jawada was 28 years ahead of his time. Is that what you're saying?
Well, I think so, and I think that the majority, perhaps in 1995, there were practical problems that existed. But I think since then, the developments like this court had in Ellis and the technological developments have changed that. Now, agreed. If a trial, I'm not trying to say a trial court must have video. If a trial court applies the incorrect standard, the case is remanded back, and the trial court is now tasked with exercising the proper function of the 13th juror. And it feels that it's been too long, it has a written record, but it feels it really needs to weigh the credibility of the witnesses, and it can't. Then the trial court, in its discretion, should be the party to make that determination and order a new trial, which would be absolutely appropriate if that were the case.
You do agree that criminal cases and civil cases should have the same rule, 13th juror rule, and what we do here, correct?
I think that they should, but I don't think it's required. I don't think there's anything in Rule of Criminal Procedure 33D that would prevent the trial court from applying the correct standard, but I understand in a criminal case you're dealing with potential incarceration of a defendant, and to the extent the court wants to preserve superior rights to a criminal defendant to get a new trial, then I think we could absolutely have a different standard and it would be totally manageable. Remember, in this case, the posture that this case took is not possible in a criminal case. In a criminal case, only the defendant can move for a new trial based on 13th juror. The state, if they can't meet their burden of proof, they don't get a new trial based on 13th juror. In this case, the plaintiff, the party with the burden of proof, was unsuccessful at trial and is the party that asked for the new trial based on 13th juror. So that posture is already impossible. To the extent that there would be a separate standard, we think that would be manageable. There's separate trial courts for civil and criminal cases. There's separate appellate courts for civil and criminal cases. I don't think there would be, the court is not obligated to apply the same standard for civil and criminal, but we believe that it certainly could, and it wouldn't be a serious issue.
I believe we said
Could I follow up on
Yes,
that
sir.
a little bit? Moats was a criminal case.
Yes, Your Honor.
Okay. Your case is a civil case.
Yes.
They're different burdens of proof.
Yes.
So there's a different role for the trial judge to play in exercising his role as the 13th juror, right? Because there's a different burden of proof. Correct?
I believe the standard, I don't think there's a material difference for the 13th juror. I believe the standard is to pass upon the evidence and determine whether they agree with the jury's verdict. Whatever the burden of proof may be, did they agree that the jury appropriately considered that burden?
Oh, okay. The standard, I'm not talking about the standard, but in exercising the role, there would be a different burden of proof applied in trying a criminal defendant, right, beyond a reasonable doubt.
No, certainly there's a different burden of proof in a criminal case.
As opposed to more likely than not. That's all right. But you started your argument by saying, I think Justice Bivens asked you, are you asking us to overrule Moats? And you said yes, correct?
Yes, and you raise a good point. Perhaps it does not need to be a direct overrule of Moats to the extent the court intends to apply this rule only in the rule that we advocate only in the context of civil cases. Then that's a good point, Justice Tarwater. We would not necessarily require it. I believe my position is the court can, and there would be we don't see any problem with that, but it is not required to do so. To the extent the court wanted to preserve a mandatory new trial in all cases in criminal matters where the trial judge didn't exercise the 13th juror function, that would be fine and apply a different rule in civil cases. The position that it would create this irreconcilable conflict between civil and criminal, we don't think applies even if there were separate standards. We don't think it's necessary, but certainly the court could do that, and we would still advocate for the position in a civil case like we have here.
Let's assume for a moment that we rule in your favor on the 13th juror issue, but we rule against you on the unjust enrichment claim.
Mm-hmm.
Wouldn't that mean that if we were going back, you're going back for a new trial anyway?
We would be going back for a new trial, I believe, on the issues that were not litigated. It would be on the unjust enrichment issue. A jury has already conclusively determined a unanimous verdict on many other tort claims at trial. So I imagine that if it was just the unjust enrichment claim, it would be just that. I would like to talk about unjust enrichment. I only have 10 minutes, and we raised one issue. There were two other issues raised, so we're not totally clear as to which issues the court wishes to hear about, but I will, Justice Bivens, talk about unjust enrichment for a moment. The unjust enrichment claim, as well as this novel, new tort for theft or trespass upon intangible redemption rights, those claims we think are indicative of the problems with the plaintiff's case throughout this case. The defendant's position has consistently been whatever conduct the plaintiffs allege the defendants did, the plaintiffs cannot establish a monetary injury proximately caused by the defendant's conduct. That's the problem, right? And so what we believe has occurred here is there are ample torts that could be raised and that were raised, but the plaintiffs, recognizing the inability to prove the essential elements of the claims they raised, because nearly every civil claim has essential elements of causation and damages, is an attempt to dramatically increase the scope of unjust enrichment or go even further and create new tort law to capture the claims that they've raised here that are not otherwise actionable. For unjust enrichment, and this is frankly something that we have seen, is it has now become a catch-all, put it in every complaint allegation, because it's difficult to fathom a tort claim that could exist where a defendant is not enriched by a plaintiff in a way that's unfair. Seemingly, that would encapsulate every conversion claim, that would encapsulate every breach of fiduciary duty claim, quite a few fraud claims.
Well, but isn't the issue here with regard to whether it requires a voluntary action?
Yes.
Okay. So let's focus in on that requirement and put it in, well, I understand your other arguments, but that's the specific issue we need to focus on here. And in that context, let me give you an example.
Okay.
Let's say that I go to a bank, I go to Regions Bank, and I'm not a customer of Regions Bank. I have a check from a friend of mine for $1,000, and I go in to cash that check. I go to Regions, give it to them. They hand me $2,000. I have to pay that back, correct?
Yes.
And I didn't voluntarily do something wrong in that instance. It's an envelope. I didn't even realize I had that. So why, in that context, if the actions can be involuntary and there can be a requirement to pay something back, wouldn't that be the same thing for an unjust enrichment claim?
If I'm not mistaken, in that hypothetical, Justice Bivens, you would be the defendant in the unjust enrichment case. You're the party that received the $2,000 that you shouldn't have otherwise received. The bank, the party that has been deprived of this benefit, would be the plaintiff in that action, and they did engage in a voluntary conference of a benefit. They gave you the money. So I think that would support a voluntary conference.
How do you define voluntary? There seems to be a little bit of debate about that between the parties about what does voluntary mean, and if we were to adopt a limitation like this, I think we would need to provide some guidance about what that is.
Yes, Justice Campbell. I believe a voluntary means an intentional act of the plaintiff or an agent of the plaintiff to accomplish a specific purpose. Now it could be a mistake. Like an intentional act is giving the $2,000. The mistake is the party to whom I gave the $2,000. Perhaps it's the wrong person, but it is an intentional volitional act to engage in the transfer of the benefit.
So if they were deceived into taking that intentional act because of a misrepresentation or that, in your view, would still be voluntary because they would still be taking the intentional act, even if maybe they wouldn't have taken it had the information available to them been different.
Yes. Now, in that context, I think you'd also have a fraud claim. And I think that if we look at
But in your view, there could also be an unjust enrichment claim there.
That's a hard question. I believe that my position is, in the hypothetical that was given, where there is no other tort that would work for the conduct alleged and the result would be unjust and there is a volitional voluntary act, then it would apply. But in the context that Your Honor just provided, I'm not sure I would agree with that, because I think that unjust enrichment is not intended to be a gap-filling tort when a plaintiff cannot prove the essential elements of his claim.
So would you need to define voluntary differently?
I would say that I think B&L was correctly decided, right? Because I do think it involves a voluntary conference of a benefit, and I think if you look at the context of unjust enrichment, as this court held in Paschal's in 1966, synonymous with quasi-contract or quantum meruit, the context of unjust enrichment is in a quasi-contractual circumstance when there is an intent to provide some benefit and an intent to receive something in return, which you can't receive for some absence of a contract. In B&L, they faced a completely different circumstance. That was a standard run-of-the-mill unfair competition, breach of fiduciary duty, fraud case where unjust enrichment was simply lumped in. And the court, I think, correctly noted that unjust enrichment requires a voluntary conferring of a benefit because it's looking at it in the context of quasi-contract. I think in this case, go ahead.
I'm sorry to interrupt. I want to, you rely heavily on B&L, understandably. But B&L didn't cite anything for that notion that you do have to have a willingly conferred benefit. And looking at some other authorities like the restatement, first and third restitution, the consensus view at least appears to be that there is no limitation along those lines, or at least that courts have not traditionally applied that limitation. Is there any other authority you can point to other than B&L to support your position that that limitation exists?
Well, I believe I can point to the Supreme Court authority that with Paschal's, Whitehaven, ACHI, all the cases we cited in the brief that discuss unjust enrichment as a tort claim in the context of quasi-contract, where I think there may be confusion with respect to like the restatement of restitution, is the conflation of unjust enrichment as a claim with essential elements. Plaintiff confer a benefit, defendant appreciate the benefit, and it would be unjust to maintain, versus unjust enrichment as a concept in the form of remedy. That I think has been some disagreement between the parties in the briefing in this case is, for example, a constructive trust may be imposed in a breach of fiduciary duty case against the embezzling or bad actor officer as necessary to prevent unjust enrichment.
Well, but can you point to any other, I know you've included a lot of, citations to various cases, but none of those cases, as far as I could tell, other than B&L, actually, expressly imposed a limit along the lines you're asking us to adopt. Are there any secondary sources? Are there any cases from other jurisdictions that have adopted that sort of limit expressly?
As far as expressly use of the word voluntary, that I'm not sure. In the Corsello case we cited
that's what I'm asking. You're referring to just the elements of an unjust enrichment claim that we've set forth in the past, which, I think you're inferring a lot into those to come up with that limit, based on how we've articulated those elements in the past. So I'm asking if there are any other cases, any other authorities you can point to for that go beyond just stating the elements of the unjust enrichment cause of action in the same way that we've stated them in the past, and actually say something along the lines that B&L said.
Yes.
That there is in fact this voluntarily conferred benefit
As I stand here today, what I would point to as the closest answer to your question would be the Corsello case. We said it in our brief out of New York, and that goes further than just saying unjust enrichment doesn't apply. That makes clear, similar to the Wachter case in the Middle District of Tennessee, they both, because Wachter relied on B&L, but they start with the proposition that unjust enrichment is not a cause of action that can be used in any situation where a defendant benefits from a plaintiff and it's not fair. It's much narrower than that. It is not a gap-filling tort. And in that case, very similar to in B&L, and I don't want to keep talking about B&L, but in Corsello, the idea was if it's duplicative of another tort, it doesn't apply. If it's used to gap-fill missing essential elements of another tort, it doesn't apply. Similarly, in B&L, that was fundamentally a breach of fiduciary duty case, and that's what the court treated as. It's not an unjust enrichment situation. It doesn't apply. I think that the voluntary requirement can necessarily be inferred from the line of cases that discuss unjust enrichment. They all involve that concept. So I don't think B&L decided that out of nowhere. I think that's implicit in the fundamental understanding of the limits of unjust enrichment as it's been established. And in this case particularly, both with respect to unjust enrichment and the request to create a new tort claim, fundamentally what the allegations were in this case is that the defendants who had no legal right to an instrument in property, recorded documents in the Register of Deeds, published these documents, and purportedly caused some injury to the plaintiffs. That is a cut and dry defamation of title claim, right? The problem with defamation of title is the plaintiff has the burden of proving malice, but more importantly, the plaintiff has the burden of proving that there were damages proximately caused by the defamatory action. That case was pled, that case was tried before the jury of 12 over 6 days, and there was a unanimous jury verdict on that. We think that parallels B&L and the other cases that have discussed the limits of unjust enrichment, in that this use of unjust enrichment in this broad manner, or this request to create new tort, is designed to gap fill the problems in what this case fundamentally is based on the allegations, a defamation of title claim with no damages proximately caused by the alleged defamation. So we believe that the Court of Appeals that the trial court appropriately relied on B&L, and that the Court of Appeals appropriately relied on B&L to dismiss the unjust enrichment claim and affirm that dismissal, as well as affirming the dismissal of the novel theft of intangible property claim. Thank you.
May it please the court, my name is Gino Bolso. I am here on behalf of the plaintiffs' appellees. Obviously, as the court is aware from having reviewed the briefs, we've got 3 sets of issues for the court. The first one concerning the 13th juror rule, the second concerning unjust enrichment, the third concerning whether the court should recognize a tort for intentional interference with a right of redemption. And I'd like to begin first by addressing 13th juror rule and pick up with Justice Campbell's questions regarding waiver, because in our view, that truly is dispositive. First, under the record, there has been a waiver, and then secondly, under the circumstances of this case, this court should not exercise its discretion under Rule 13 and allow the appellants to raise this issue regarding the 13th juror. First, why has there been a waiver? Well, for the very reason that this issue about whether the court should abandon the remedy for violation of the 13th juror rule is something that should have been raised before the appellant's petition for rehearing in the Court of Appeals. It was, as Justice Campbell pointed out, an issue that was directly raised by our brief in the Court of Appeals as appellants. We specifically requested that the Court of Appeals not only reverse the court's ruling on the new trial motion, but also remand for a new trial. And it was at that stage that the appellees, the defendants, should have raised this issue had they wanted to. Secondly, we know that in Payne, this court specifically held that when a party waits until a petition for rehearing to raise an issue, it is waived. And for good reason, because that's too late in the appellate process to have the Supreme Court now addressing issues that have never been addressed before. As the court knows, when we look at Article 6, Section 2 of our Constitution, what's clear is that this court's jurisdiction is appellate only. So typically, it is reviewing a decision of a court of appeals, which previously had reviewed a decision of a trial court. And that's really the way the appellate process needs to work, because at each stage there's value added. A trial court looks at an issue, makes a decision. A court of appeals looks at that same issue to decide whether the trial court erred or got it right.
Counsel, I'm sorry to interrupt,
Sure.
but does it make a difference here that this is an issue, to the extent they're asking us to overrule motes? I mean, that's something that the Court of Appeals could not do. So does that make a difference in determining whether there was a waiver here? The fact that the Court of Appeals may not have been able to actually grant the relief that they wanted?
Yeah, respectfully, Justice Campbell, it does not make a difference, because although the Court of Appeals could not have overruled motes or any of the other hundreds of cases decided between 1796 and 1995, the court could have analyzed the issue that was requested, which actually happened in motes. When the court looks at the Court of Appeals opinion in motes, the Court of Appeals in that case actually dealt with this issue about whether the remedy for a violation of the 13th juror rule should be a new trial or a remand to have the court properly address it under the proper standard. So the fact that the Court of Appeals in this case was not in a position to overrule Moats does not undermine the fact that the waiver occurred. And one of the things that I've noticed with our General Assembly is that, we have bills that represent the policy of the state that go through subcommittees and then committees before they're ever advanced to the full House. And there's significant value in that process because at each stage the issue is vetted. New perspectives are added. In here, there was never an opportunity for any of the courts below to give this court a perspective to review. And the reason that this court should not, as a matter of discretion, get into this issue is simply because look at what is being asked for. It's not simply overruling Moats. This 13th juror rule and the remedy attendant to it came to us from the common law when the state was founded back in 1796. So it's not just an issue that was never raised. It's an issue that asks this court to overrule 227 years of precedent, which is, in my view, somewhat unprecedented, that a party could actually come before this court, never having raised the issue, and suggest that this court on its own, with no record to review, there's no record of any kind, there's no prior decision, and just reverse 227 years of precedence. That would not, in my view, respectfully, be a prudent exercise of the court's discretion. So, in our view, the court should not even reach the issue. Nevertheless, should the court decide to reach the issue, we submit the court should not adopt this position that the appellants have advanced, that we ought to change the remedy for a violation of the 13th juror rule. Because the rule that we have, as Moats points out, is there to safeguard against a miscarriage of justice. That's the whole idea. We want the trial court to be able to look at the same evidence, the same witnesses, the same documents, the same exhibits that the jury did, and make a decision about whether the jury actually arrived at the right result. That protects them.
Excuse me.
Yes.
How do you respond to Justice Rowoda's dissent when he says, he was a trial judge, and there are some cases that he could remember them just like it happened yesterday, and others that he would be foggy on, so why shouldn't we just leave it to the trial judge to make that decision, whether he or she can go back and apply the proper standard rather than a completely new trial?
Well, for two reasons. One, Justice Rowoda did say that that process only works where the trial judge has an independent recollection of the evidence and of the witnesses. So even in dissent, Justice Rowoda would not endorse what the appellants here are asking this court to do, which is that even without a demonstration, that a trial court who tried the case has an independent recollection to go ahead and just remand it to whoever the judge is. The second reason, Justice Page, is that in this case, we no longer have the same trial judge. As the court knows, just about a week after the Court of Appeals issued its opinion in this case, Chancellor Martin recused herself. We don't know exactly why. She simply cited Rule 2.11 of the Rules of Judicial Conduct as a reason for recusing herself. So even if we had someone as talented as Justice Rowoda back in the trial bench and remanded this case, it would go to a completely different judge because Chancellor Patricia Moskal now has the case. So that that process would not work well.
Well, does that bring us into the Ellis situation then?
Yes and no, Justice Bivens, because when we look at Ellis, one thing that we saw was that it was, in one sense, a ruling out of necessity. I mean, sometimes in the judicial system, finality is always at war with validity. You want to get it right, but you want things to be final. And in Ellis, you had a case where you had a judge who presided over the trial, obviously, became disabled and was not able to go ahead and render any decisions regarding the post-trial motions. So in that specific instance, this court determined that, on balance, it was a sufficient safeguard where a judge had to be replaced in favor of a different judge to go ahead in a fairly prompt manner, nevertheless, and resolve all post-trial motions, including a motion to set aside a verdict on the basis that it was against the weight of the evidence.
But, counsel, is that a consistent standard? If we have case law that says an entirely new successive judge could exercise his or her discretion, but the same trial judge, if that were available, could not. So I'm scratching my
Sure.
head a little bit about why we should have a harsher default rule I mean, we have an unusual situation here where it's not going back to the same trial judge.
Sure.
Anyway, but typically it does.
Typically it does, and my response, Madam Chief Justice, would simply be this, that to a small degree, Ellis weakened the safeguard against the miscarriage of justice. Not much, but a little bit, but it did so out of necessity because the judge was gone. What, in our view, the court should do would be either to leave the safeguard as strong as it currently is, or possibly strengthen it in some other manner. But it would not be logical to take Ellis, which simply in one narrow instance allows a replacement trial judge to exercise the 13th juror role, and then expand that to all criminal cases and all civil cases as a new remedy on appeal. That would respectfully weaken the entire safeguard across the entire system. But Ellis actually suggests another way that we could strengthen it without doing that. If you look at footnote 10 in Ellis, the court wrote that trial judges are encouraged to exercise their obligation as the 13th juror as promptly as possible. In other words, do not wait for a motion for a new trial, which is going to be 60 or 90 days after the verdict comes in. And one thing that we could do to strengthen the safeguard is to look at a rule change. I mean, it's Rule 59.07 that governs the right to a new trial on the basis that a verdict is against the weight of the evidence. And we could this court could literally take footnote 10 from Ellis and in Rule 59.07 specify that a trial court should make its determination about whether it agrees or disagrees with the jury verdict within 3 business days, 5 business days, some period of time, so that you actually have got the ideal circumstance. You've got a trial judge still with the evidence and the testimony fresh in mind, making a decision about whether the jury arrived at the correct conclusion. So if there were to be a change, in our view, rather than disposing of 227 years of precedent, we could achieve the same thing by perhaps strengthening Rule 59.07, because this is not an issue that happens very often. This is an issue that it's easy for trial judges to get right, and across the state every week, trial judges do. Because when someone asks a judge to set aside a verdict on the basis that it's against the weight of the evidence, it presents just a single question to the judge. Do I agree with what those 12 ladies and gentlemen in the jury box just decided? If the answer is yes, then the court denies the motion without comment. If the answer is no, the court sets it aside without comment. That's it. And regrettably in this case, although we had a very talented trial court, the court just made a mistake and for some reason applied the wrong standard. But if we actually put the precise standard in Rule 59.07 and require judges to use that standard within a time that's very proximate to the verdict, we would have actually strengthened the entire safeguard rather than doing what appellants suggest and take this narrow area where you have a judge that becomes disabled who's now going to go ahead as a replacement judge and make a pass on whether or not the judge can intelligently decide whether the verdict is against the weight of the evidence or whether the judge agrees with the jury, and then expand that all the way to all criminal cases and all civil cases. So if there's something to be done here consistent with our precedent, in our view, it would be to strengthen the safeguard by beefing up Rule 59.07, not weakening the entire chain that's done us great service for 227 years. I mean, obviously there are other ways to have safeguards. The federal system has a different way. I mean, they use the reasonable juror standard. You know, was it against the clear weight of the evidence? We've seen other states, and this is referenced in Moats. State of Ohio actually has appellate courts acting as 13th jurors, which is kind of an interesting concept. But the system we have in Tennessee has just worked so well for 227 years, and the idea that we would abandon it on the basis of an issue that's raised for the first time in this court, in our view, is antithetical to the way the judicial process should
I don't
work.
want to keep you from getting to your unjust enrichment
Yes.
argument. I know you want.
Unjust enrichment, another just wonderful claim that we have here. And obviously, we've asked this court to reverse the Court of Appeals decision affirming the trial court's granting of the 12.03 motion for judgment on the pleadings as to that claim. And here's respectfully why this court should reverse the Court of Appeals. First, we have 4 plaintiffs who tried claims in this case beginning on September 14 of 2021. The claims are similar in most respects. There are some nuances, but let me focus on the claim for Carl Chambers. Mr. Chambers owned property at 2131 11th Avenue North in Nashville, just off of Dominican Boulevard, right next to the Maxwell House Hotel. Been in his family for decades, going back into the early 1900s. And it was sold at a tax sale because after his mother died in 1972, other relatives started living there. Ultimately, his uncle lived there, died. There was no one left to pay the taxes. So the tax bills went unpaid. The Metropolitan Government of Davidson County went ahead and sold the property at a tax sale. That created this thing called a right of redemption in Mr. Chambers and his other siblings, because they were the heirs of Maggie Chambers, who was the last record owner of the property. And what occurred here was that Mr. Charles Walker, using a forged quitclaim deed, allegedly signed by a notary in Dallas, Texas, Jennifer Clark, acted as though Mr. Carl Chambers and his heirs had assigned to Mr. Walker's company this right of redemption. He literally forged a quitclaim deed and used that to take the right of redemption away. So as an attorney, you have a client that comes to you and says, here's what happened. This property was sold. I had this right of redemption that lasted a year. And this gentleman, Mr. Walker, who also happens to be an attorney, used a forged quitclaim deed to get the right of redemption and then ultimately sell the property for $28,000. So as an attorney, you ask yourself, well, what cause of action do I bring to vindicate Mr. Carl Chambers' rights and those of his siblings? Well, the first one that came to my mind was unjust enrichment. That was a terrible thing to do. Mr. Walker had never met Mr. Chambers. The evidence is clear about this. They never had any communications of any kind. So it's not the type of a fraud where there's a misrepresentation upon which Mr. Chambers relied. So it doesn't naturally fit into our jurisprudence under misrepresentation. But what he did was he used this forged quitclaim deed. He went in and redeemed the property for $2,219 and then resold it for $28,000, making a profit of just under $26,000. And in our view, unjust enrichment was the natural cause of action that we should have been able to try. It's the one that we wanted to try because of the simplicity of it. And then the second thing that occurred to us was that, gee, the man stole a right of redemption. He literally took a quitclaim deed, forged it, and stole the man's right of redemption. Well, we all know conversion in Tennessee is only a cause of action with regard to tangible goods, not intangible rights. And we looked at the law, and one of the things we saw from Judge Clement's opinion in Curtis in particular was that where you have an intentional interference with a real property right, the law gives a remedy. And that was dealt with an easement. In the Curtis case, you had defendants that intentionally interfered with the plaintiff's easement right, and the Court of Appeals in the Curtis case said, look, if you prove that there was an easement, you prove that there was intentional interference, and you prove that there was damages that flowed from the intentional interference, you can recover. And we asked the trial judge to let us do the same thing with the right of redemption. It is an intangible right, what the law often calls in incorporeal hereditament. It's not something that arises very often, but it arose here. And so those were the two immediate causes of action that came to our mind. One, unjust enrichment, and then two, this idea that we should have an intentional interference with the right of redemption. Well,
Counsel, I'd like to ask you the same question I asked your friend on the other side, which is, how do you define voluntary?
Sure. I would define voluntary, Your Honor, as in accordance with one's will. In other words, a voluntary act is one that's in accordance with what one acted, in accordance with one's willful act. Whereas intent is actually an act of the intellect. This is something that Thomas Aquinas wrote about in the Summa Theologica. But when you look at voluntariness, it's an act of the will. You look at intent, it's an act of the intellect. And we can actually illustrate that with our own cases. We look, for example, at Pascal's, the seminal 1966 unjust enrichment case. There, you had a contractor that entered into a contract with the daughter of the owners of the home. He did a bathroom renovation. And it was known to everyone that he was going to do the work and the daughter was going to pay him, not the parents. So he goes in, remodels the bathroom, and the daughter files bankruptcy and won't pay. And he unfortunately allowed his lien rights to lapse. So he went against the owners of the property for unjust enrichment. There, he voluntarily built the improvements, and he intended to benefit the owners of that property. So there, in Pascal's, you had a unity of voluntariness and intent. Now take the 2014 decision in the In Re Estate of Ross case, which was one that we handled before the Court of Appeals. We had Mrs. Ross, who spent $417,000 building a home on property where she thought she was the record owner, along with her son. Turns out she wasn't. She built a home. The property, the fee interest, was only in her son, Paul Sirachi's name. And so we brought a claim for unjust enrichment in the probate court. We're successful, and the court awarded $417,000, affirmed by the Court of Appeals. There, her act of building the home was voluntary, but it was not her intent to give that benefit to her son who owned the property. See, that's why the one line in B&L, although in context, is not necessarily a bad line, but it has to be applied only in the cases like Pascal's, where you're suing for quantum meruit, where you have a unity of voluntariness and intent. Because there are many precedents we have across the last 200 years where this court has recognized that in involuntary cases, you may nevertheless have a remedy in unjust enrichment. Justice Bivens presented a very good hypothetical about where you would have unjust enrichment that was involuntary from the bank's perspective. They didn't mean to give him $2,000, obviously. But look at the Creech case that we cited in our papers. That involved the conversion of an automobile. So the automobile is stolen. It makes its way ultimately into the hands of the defendant, and the plaintiff sues in unjust enrichment to get the car back. The plaintiff, in that case, for whatever reason, decided not to use a conversion remedy that might have been available as an intentional tort. And there, the Creech court said, yes, the plaintiff can recover on the implied contract. There was nothing voluntary about the plaintiff's parting with ownership of the automobile. It was stolen. And yet, in Creech, this court recognized that states a valid claim for unjust enrichment. And in ruling that way, it relied upon the McCombs case from the 19th century, which is identical, except that it involved a piano. You had a piano that was converted. And the McCombs case says very clearly that where you've been the victim of a conversion, you can waive the tort and sue on the implied contract. That's what happened in McCombs. That's what happened in Creech. Take the Beeler case, which we also cite, also involuntary. There you had the employee accept $117,000 in bribes, and the employer sues to get the money back, $117,000. Is that a valid basis for an unjust enrichment claim? Absolutely. And it needs to be measured by the benefit to the defendant, because here, whether or not the contracts that were awarded that were the subject of the bribes, benefited or somehow financially harmed the employer wasn't the question. The question was whether there was a remedy and restitution for that $117,000. Beeler said yes. That's another involuntary case. So we've covered already in just these few minutes 3 cases where our courts have said, even where the act was involuntary, that the remedy of unjust enrichment exists. The conversion of the car, the bribe in Beeler, and then building the home on property that Mrs. Ross thought belonged to her.
What about the defendant's argument here that unjust enrichment really isn't intended to be kind of an all-inclusive sort of claim? That it's not intended to be sort of a substitute for other claims that might be a better fit for the allegations in question. Even if we don't go so far as to adopt the limit that defendants are advocating for here, are there other limits that we could adopt to ensure that what defendants have, fear might happen, would not happen?
Yes, there certainly are, Your Honor. And I think we need to step back for a second and reflect on the fact that what caused this problem was a line in one case in B&L for which there was no citation of authority. And in the context of B&L, it was likely an accurate statement of the law, because B&L was just like Pascal's. It was an issue about whether there was some type of a quantum merit that was available in that case, where you had the employees that took the trade secrets and the customer list. So really what the remedy that would be the most efficacious is for the court to effectively confine B&L to its facts, because the rest of our law for the last 200 years is fine the way it is, because there are elements to these different types of involuntary conveyances that form the basis for a claim for unjust enrichment. And in this particular case, and Justice Campbell, you referred to it earlier, you look at the restatement first of restitution. You look at section 137 of it, and it says specifically that if someone tortiously acquires ownership of land, then that person will be liable in restitution to the true owner. That's our case. And so if this court simply adopted explicitly restatement first, section 137, that would avoid these issues about somehow a remedy of unjust enrichment swallowing up tort law. It won't. Or you can move forward to section 40 of the restatement third of restitution, which effectively says the same thing, although in other words, the language is more modern. That talks about if someone acquires a benefit unlawfully or tortiously with regard to any type of a tangible asset, including real property, that person shall be liable in restitution to the true owner. So there are guardrails on unjust enrichment, and they already exist in our law. So really, we're not asking the court to adopt or create a new cause of action in any respect. All that we're asking respectfully is that the court recognize that the language in B&L either be confined to its facts or that language be overturned, because the rest of our body of law is great. It's perfectly clear. And I think, as has been pointed out earlier in the argument, there are no cases until this one in our state court system that applied B&L in the manner that it did. The only other cases out there are these federal cases that for some reason, perhaps under Erie, felt obligated to apply that sentence about willfully conferring a benefit because it was there. But all that we need to do is to make that one tweak. We need to restrict B&L or overrule it on the basis that we do have involuntary transfers that can form the basis for unjust enrichment. We do not need to rewrite anything else with regard to unjust enrichment.
Mr. Bosso, let me ask you a question here. Let's go back to Mr. Chambers.
Yes.
He filed his claims for, I think, fraud and trespass and civil conspiracy, had a jury trial and lost, right? Only Ms. Irvin prevailed at trial. Isn't that correct?
I'm sorry, Your Honor?
Only Ms. Irvin prevailed at trial.
That's correct, Your Honor. Yes.
So if we agree with you on unjust enrichment, regardless of what we do with respect to reversing motes, I think Justice Bivens alluded to this earlier, we're still going to have to send this back for a new trial on unjust enrichment, right?
Correct, yes, Your Honor.
Okay.
And frankly, if we try this case again, as lead trial lawyer, I can tell you, I would not try it under the basis of a misrepresentation by concealment or defamation of title claim, because those are the claims that we were left with after the trial court's dismissal of the claims we really wanted to try. But they're very messy, again, because there was never any contact between Mr. Walker and Mr. Chambers. And so it became very difficult to prove the misrepresentation, the reliance on it, and all the other elements that we've got. So respectfully, we would request that the court reject this argument about the 13th juror rule. We would ask that the court reverse the Court of Appeals with regard to the dismissal of our unjust enrichment claim. And then finally, we would request that the court reverse the Court of Appeals rejection of our intentional interference with the right of redemption claim, because that claim is a direct parallel to the intentional interference with easement claim that Judge Clement in the Middle Section Court of Appeals adopted in Curtis. Thank you.
Mr. Bulso,
Yes.
before you go, and the yellow light's on, so we got a little.
Okay.
I'm curious, when applying the wrong standard by the trial judge, sitting as the 13th juror, the case goes up. There's going to be a remedy then. It's going to be fixed by the Court of Appeals or by the Supreme Court. Does it matter if it's a criminal case or if it's a civil case in fashioning that remedy? Because it seems that Justice Strawoda's opinion would lend itself to application in civil cases, and as opposed to overruling Motes, which is a criminal case. And I wondered how you feel about that.
I feel that we ought to have the same system that was in place before 1975 when we got away from having a 13th juror rule in criminal cases. I mean, for most of the history of the existence of our state, the standard has been the same in both civil and criminal cases. And in our view, that's the way it should be. And in fact, when you look at the decisions that followed the adoption of Rule 33D, it's clear that the intent of the rule was to adopt to reestablish the common law that existed prior to 1975, which included both the 13th juror rule and the remedy. So in our view, whether it's a criminal case or a civil case, the trial judge is asked the same question: do you agree with this verdict? And the answer is yes, you deny the motion. The answer is no, you set it aside and you have another trial. There should be no difference, criminal or civil. Thank you.
Thank you.
Mr. Hildebrand,
Yes, sir.
let me ask you a question since I've got the mic now for a bit. Unjust enrichment is rooted in equity, am I correct? And you tried this case in Chancery Court?
Yes, that's correct.
Okay. So then, what difference does it make to whether the benefits conferred were voluntary or involuntary if the defendant was unjustly enriched?
The difference lies in whether we're talking about Chancery's goal of remedying enrichment that is not fair versus the claim of unjust enrichment, which itself has essential elements. I think in the former, Chancery rectifying wrongs in a variety of tort claims, then that voluntariness requirement may not be necessary. I believe, as Mr. Bolso, the examples he gave, talking about conversion of an automobile, conversion of a piano, waive the tort. Those are, waiving the tort is a manner in which the remedy could be designed to prevent an unfair enrichment, but that is separate from the claim of unjust enrichment. The claim is conversion, which requires a taking of a chattel in defiance of the true owner's rights. If if unjust enrichment, the claim, were to be applied in that situation, then theoretically, a plaintiff could simply succeed on a conversion claim without having to meet the essential elements of conversion. So I agree completely. In a chancery context, constructive trust, for example, that is an equitable remedy that can be fashioned to prevent an unjust enrichment, but it doesn't have to be applied in an unjust enrichment claim. It could be applied in a breach of fiduciary duty case or in a conversion case, as we saw. With respect to the claim of unjust enrichment, though, I think it's different, and I think that's been conflated. Specifically, I didn't mention this before, but in the Whitehaven case from 1998, this court was discussing unjust enrichment. That was about a church that was developing property and its contractor wasn't paid and wanted to sue the lenders. And the court in that case said that as a prerequisite to recovery for an unjust enrichment claim, the plaintiff has to exhaust the remedies against the party with which it owed privity. That's a condition precedent to pursuing unjust enrichment, according to the court case in 1998. To me, that necessarily implies that when we're talking about the claim of unjust enrichment, we're talking about a quasi-contractual situation, which is fundamentally different than equitable remedies that a trial court may fashion to prevent what I would call lowercase UI, unjust enrichment. That would be the answer I would give to that question. I want to briefly touch on this. I believe it was mentioned that Ellis is a limited, isolated opinion that covered a very limited set of circumstances. The way I read Ellis is there is now a presumption in all cases that a successor judge may serve as the 13th juror based on a written record. So to the extent the reason that that rule was applied, I can't speak to. What I know is that what that ruling states is that all successor judges are de facto able to serve as the 13th juror on a written record unless there is some showing by a person opposing that with the burden of proof that that's not appropriate. I don't think that's a limited case. I want to address also the proposition that was raised of, well, the trial court, a better rule would be for the trial court to decide this very quickly, the 13th juror. Well, this was raised at the Court of Appeals, but our contention is that already happened. The jury entered its verdict, reached its verdict, and a day later, the trial court entered an order. It called that order a Rule 58 judgment, entering a judgment in favor of the defendants on all claims except for the limited claim for Ms. Irvin against one of the defendants, and taxed court costs. So our position at the Court of Appeals was, we don't need to talk about the appropriate standard. The court already raised it. So the issue of the court should act quickly to apply the standard, we contended that did occur.
But did that order specifically address the 13th juror issue?
It did not, but we implicitly would suggest it did because it adopted the jury's verdict. Then the court ultimately denied the motion for a new trial, but we're not here to relitigate whether the standard was applied. I just bring that to mention that under that hypothetical, theoretically mistakes could still arise. With respect to Mr. Chambers, briefly, this idea that unjust enrichment was the only logical claim that could work, we reject that. The claim is that somebody took a fraudulent deed claiming that they had title to property they did not have and recorded it, published it with the Register of Deeds, and caused harm. That's the essential elements of defamation of title. The problem was that there was no causation or damages associated with that could be established. So the idea that unjust enrichment is the only claim, no, the claim that best fit this circumstance was the claim that was alleged, was litigated, and was unsuccessful after a 6-day jury trial. Thank you.
Thank you, counsel, for your fine arguments. And that completes our docket for this afternoon.
All rise.